Hi, it's the Florida Law Guy. Today we're going to talk about equitable distribution and the 10 factors that a judge can look at to determine whether or not it's appropriate to give a non-50-50 distribution of the assets in a divorce. When people get divorced, the court needs to divide up the parties' marital assets and debts in a process called equitable distribution. There are two crucial things to note about this. First, equitable distribution only deals with marital property. If property is not marital property, but is determined by the judge to be non-marital property, then it is not subject to equitable distribution. Second, notice that it's not called equal distribution, but equitable distribution. Equal and equitable do not mean the same things. Equal means 50-50. Equitable is a fancy word meaning fair and just. In other words, it is the job of the judge to divide up the assets between the spouses in a way that is fair and promotes justice. When deciding what is fair and just, the judge begins with the presumption that a 50-50 equal division is what's fair and just. However, the judge has a duty to look at 10 other factors as well to determine if a non-50-50 distribution is equitable under the particular facts and circumstances of each case. The first factor is the contribution made to the marriage by either spouse, including contributions to the care and education of the children and any services made by one spouse as a homemaker. The second factor is the economic circumstances of the parties. If one party has more non-marital assets than the other and is independently wealthy, that is a justification for a non-equal distribution of the assets. The third factor is the duration of the marriage. The fourth factor is any interruption of personal careers or educational opportunities of either party. The fifth factor is the contribution made by one spouse to the personal career or educational opportunities of the other spouse. The sixth factor is the desirability of retaining any asset intact and free from any claim or interference by the other party. This normally occurs when one of the spouses has their own business. For instance, a judge is not going to dissolve a medical doctor's practice as part of a division of the assets. The seventh factor is the contribution of each spouse to the acquisition, enhancement, and production of income or the improvement of the value of assets. The eighth factor is the desirability of retaining the marital home as a residence for any child of the marriage until the kid turns 18 if financially feasible. Of the 10 factors, the one that is used most often by the courts to justify an unequal distribution of the assets is the ninth factor, which includes the intentional dissipation, waste, depletion, or destructions of marital assets. If the husband spends $50,000 putting cocaine up his nose during the marriage or spends money wining and dining and buying gifts for his secret girlfriend, he shouldn't be surprised when the judge compensates the wife financially for this waste. Finally, the court can consider any factor necessary to promote equity and justice between the parties. In other words, as in many other areas of the law, judges are given broad discretion. As long as the judge can justify a reason to give a non-50-50 distribution of the assets on the principles of fairness and justice, the decision would probably be upheld on appeal. It's completely free, so please support my mission to help make Florida law simple for the public to understand by liking and clicking the subscribe button. The way YouTube's algorithms work, the more likes and subscriptions a channel gets, the easier it is for others to be able to find it. So by subscribing, you'll also be helping others. Thanks for watching. See you next time.